Hello, and you're very welcome to this lecture on the topic of the Irish legal system. The lecture is going to be really an introduction to the Irish legal system. And what I want to take you through in this lecture is what is the concept of a legal system, but more particularly, what are the sources of law in the Irish legal system. So, as I have up here in the slides, the learning outcomes and the purpose of this lecture is to ensure that students will be able to discuss the concept of a legal system, to be able to identify primary and secondary sources of law, discuss how these sources of law are created, and then to be able to distinguish between various different classifications or divisions in the law. So while we have sources of law, we have divisions within each source of law that can be referred to as classifications or divisions in the law, such as, for example, public or private law or civil and criminal law. So I'm going to take you all of these step by step. So first of all, the concept of a legal system. So what is law and what are laws? So basically, laws are rules of conduct imposed by a state upon its members, and these rules of conduct constitute the law of the land, or the domestic law, or the national law. And we'll be talking about national law and international law, and maybe the differences between these two in relation to a source of law. So the purpose of the law then is to it's to maintain standards of good behaviour within society in the interests of the common good. So, law regulates human behaviour. An example of law regulating human behaviour, we can take some examples from both civil law and criminal law. So, for example, we're all familiar with imprisonment for unlawful killing or murder, or the destruction of property, and also the obligation to give compensation to those who might be injured or harmed by our negligent conduct or wrong conduct, which is the province of civil law. So law regulates these areas of law, both criminal law and the civil law, and it says that if you fall below a certain standard of behaviour, then consequences will be attached to your behaviour. So and I'll be talking later about the different institutions or organs of the state which create law, the legislature being one. So the legislature would make a law, a statute or an act of the Oireachtas in the area of criminal law, for example. And the role of the court then in this instance would be to resolve a dispute in relation to criminal conduct or a civil wrong. So the role of the court then is, if we fall below a particular standard, the court will interpret and apply the law to the facts of the case. They will ultimately come up with a decision, and the decision will lead to a remedy or to a redress, which will basically be imprisonment, for example, or a fine in criminal law, or the awarding of damages in negligence. And this is then attaching consequences to the behaviour. So law then regulates human behaviour and therefore human persons or legal persons. However, it's important to note that legal persons aren't just human persons, but are also legal entities such as state bodies or companies, for example. So these bodies are also known as legal persons, and they can own property, sue and be sued. So law regulates legal persons, but it's more than just human persons, also companies and state bodies, for example. So when I referred earlier to what is law and laws, laws are individual specific rules that you might find as a civil law rule or a common law rule or a statutory provision. So we have a number of rules or a number of principles, and they're generally referred to as the laws. And the law then refers to more of a system, such as our Irish legal system, in which the laws operate. Okay, so they interact then with each other within the system of the Irish legal system. So if we look at what is the concept of a legal system, and Raz, who is a legal philosopher, has highlighted different characteristics of a legal system. which are very true, especially in the context of the Irish legal system, where we have a set of the separation of powers. So he says that it's normative, institutionalised and coercive. And what is meant by that is that normative means that it is normative in that it serves to guide human behaviour. So it regulates human behaviour within society. It's institutionalised, and we will see this later as we go through the different institutions and maybe how the sources of law operate within each institution or organ of the state. So institutionalised in that its application and modification are to a large extent performed or regulated by institutions. So, for example, if we look at application, it's the role of the judiciary to apply the law, and modification, it's the role of the legislature or the Oireachtas to amend the law. And coercive in that obedience to it and its application is internally guaranteed, ultimately by the use of force. So if I go back to the example that we gave earlier in relation to criminal law, so if your behaviour falls below a particular standard that is expected in society, consequences will be attached to it, such as imprisonment. Okay, so coercive fits within the Irish legal system. So the Irish legal system is also referred to as a common law system. And the common law is a term that can be used to describe the overall common law system, which comes from England, which we have inherited from England, along with other countries such as America, Australia, and New Zealand. But I'll be referring to this common law system versus a civil law system, just to clarify the differences. And also then I'll be referring to common law as part of a source of law within the Irish legal system, which again I will be highlighting the difference as it being a source of law versus a system of law. So the common law system comes from England. It was first established on the Norman invasion in England in 1066, and Ireland is often referred to as the common law's first adventure. So I believe it was on the authority of the king that the common law would have impact and full force of binding force in Ireland. And since then a system of judge-made law or developing law based on judicial decision-making forms the basis of the common law system in England and then in Ireland. So the significance of a common law system, particularly in Ireland, and I'll highlight the difference between the difference between the common and civil law systems in the context of a system rather than a source of law. So the common law basically consists of thousands of decisions which span back the centuries and are based on the doctrine of precedent or stare decisis, which ensures that they enjoy the binding force of law. So basically it's a system of judicial decision making where judges of later courts have followed the decisions of earlier courts. So it's based on a system of judicial authority, and over time it has developed as a binding force of law. The importance of stare decisis that I referred to, or the doctrine of precedent, is another topic that I will be discussing in another lecture. So you can have a look for the lecture on the doctrine of precedent also, where I'll go through the principles of stare decisis in more detail. But for now, the significance of the common law system is that it is judge-made law. It's a system of judicial decision making based on precedent or following later cases following earlier decisions. The decisions are recorded in law reports, and I'll talk more about those later. And basically it's based on the fundamental principle of precedent, which ensures certainty, consistency and predictability in the law. So the difference between the common law system and a civil law system at a very broad level The civil law system being the other major legal tradition in law, which is basically based on Roman law. You'll find a civil law system in states or countries such as France and Germany, for example. The significant difference here is that civil law systems are based on the codification of law, so legislation developed by their government, which is continuously updated. Another significant difference is that the doctrine of precedent doesn't have binding force, or it doesn't operate within a civil law system, whereas in our common law system the doctrine of precedent is a fundamental universal principle that I'll talk more about again, as I said, later. So the legal system will be always based on a rule of law, or the principle of the rule of law. And central to the principle of the rule of law is the notion of limited power. So it's the idea that governmental power will be limited or restricted. So in Ireland we refer to this as the separation of powers, which ensures an even distribution of power among the three organs of government, which I've referred to here as executive, the government, the legislature, which is the Oireachtas, which I will be talking about again later, and the judiciary, which is basically the court system. So it's our constitution that sets out the separation of powers, and this ensures that power is distributed between each organ of the state, and that no one power or no one organ has supremacy over the other. It also ensures that the different organs of state are limited in their particular area, such as the courts will be limited to interpretation and application of the law. The legislature is limited to its function as lawmaker, and the executive, or the government, its function is basically the execution of the law, or ensuring the proper implementation of law. So it has a role and function in relation to policy and guidelines and strategies around the implementation, and ensuring that the law is being abided by citizens. So in relation to the rule of law, in order for it to function or operate properly, there's a number of principles that can be identified that I'll just mention. So some of the principle is basically that rights and obligations must be prescribed in a legal form and can only be altered in a manner prescribed by law, and also that individuals are entitled to fair notice of the laws which govern their conduct. And we will see this principle that individuals are entitled to fair notice of the law which governs their conduct when I talk again about the doctrine of precedent in another lecture. But for the purpose of sources of law, we're going to look at laws must be prescribed in legal form. So we're going to look at different forms of law, being acts of the Oireachtas, common law, or constitutional provision, for example. And fair notice of them. If you take the common law, for example, judgment law as a source of law that we will talk about later on, the fair notice would be the reporting of judicial decisions. I'll talk about that later. And fair notice in relation to statutory provisions or acts of the Oireachtas will be again the publication of legislation. And we'll talk about that when we look at finding legislation and finding common law later. So basically, that was an introduction to the whole concept of a legal system. So within a legal system, you have, with the Irish legal system, we have we have a system of law based on the rule of law. We have a system of law based on the notion of limited power, where three organs of the state are limited to the functions and the role of the power and the powers which have been conferred on them by the Constitution. So the rules of conduct, or the law then, are found in various different sources of law. So the next couple of slides, I want to talk about these sources of law. So sources of law are the origins of the rules and where they come from. So for example, we'll see that there are legislation, the common law and the constitutional are three of the main sources of law within the Irish legal system. But since our membership of the European Union and the amendment to our constitution, which I'll talk a little bit about later, EU law is also a very fundamental source of Irish law. So legislation, again, as I said, are statutory in nature, and they are created by the Oireachtas. And we'll look at the legislative process in a few minutes. Common law then is judicial decisions. So it's a system of judicial decision making over a number of years, and through judges applying and interpreting principles of either the Constitution or provisions found in statute. We have common law principles, that is a source of law. And then we have constitutional law, and the Constitution in Ireland, Bunreacht na hÉireann, or the Irish Constitution 1937, is the fundamental source of law. It's the most superior source of law in the Irish legal system. So if you look at a hierarchy, you'll have constitutional law and parliamentary supremacy, really, of legislation, and then we have the judiciary or the common law, where the courts will interpret the constitution and legislation and apply them to the facts of a case to come up with a decision to resolve disputes within the legal system. So I've laid out here again sources of law, and I'll be referring to them under the terms primary sources and secondary sources of law. So primary sources of law are the most authoritative sources of law, the most binding sources of law, and then you have secondary sources of law such as international law, custom law, canon law and academic commentary, and these are persuasive authorities in the Irish legal system. So as I said, we have the Irish Constitution, legislation, common law and European Union law, which are primary sources of law in Ireland. So I'm going to go through each and give you an introduction to the source of law and how they've been created. So for just a brief little history about the Irish Constitution, we have had a previous constitution in 1922. That constitution was really inherited from the British system and had a lot of influence from the British legal system. So in 1937 we replaced that constitution with the 1937 constitution, Bunreacht na hÉireann, and that constitution removed all influence of British rule from our constitution. So the constitution can be divided into two parts. Basically you have part one, which sets out the structure of the different organs or institutions within the state, and then you have part two, which deals with the fundamental rights of each citizen within the state. So it is a book, it is a constitution or a document which sets out clear legal principles and general aspirations. So the common law then as another source of law, and I referred to this earlier, so I'll just be brief again just to mention the most simplest way to understand common law is that it is judge-made law. Okay, it's judge-made law, and the role of the judiciary in the context of common law is to administer justice and interpret and apply the law. And as I referred to earlier, the fundamental difference between common law as a system and civil law as a system versus this common law as a source of law is the doctrine of precedent and the binding force of judicial decisions within the hierarchy of the Irish court system. And I will be discussing judicial hierarchy and the hierarchy of the court structure within the Irish legal system in another lecture. So you can have a look at that, where I'll go into a bit more detail about judicial hierarchy and also the hierarchy of the court system in Ireland. So if you want to find a piece of common law is often also referred to as case law. So if you were to be studying a particular topic within the Irish legal system or within the various subjects of law, such as tort law, contract law, constitutional law, employment law, criminal law, whatever the topic of the law is, if you are looking to find a case, you will find them in generally in a series of reports. So the most principal or authoritative reports in Ireland is referred to as the Irish reports, and I've given an example here. It's the Irish reports. The Irish reports have always been published in a written format, so you'll find them physical copy of them in the library, but also through electronic databases have improved access to judicial decisions, which is important in the context of access to justice within the Irish legal system. So to find an Irish report, you can find a physical copy if you go to the library, but also an electronic copy you can find online on various different websites. I've given examples here. You can go to the Court Service website and courts.ie, also Westlaw and Lexis and Justice, which you will find through the library catalogue, which are UL have, the School of Law has subscriptions to these various research aids, where you can go and find a case if you have to read it for a particular area. So I've just given an example of a citation if you were to find a report. So just a quick example of this. Basically, you will generally have a citation in the form of square bracket 2017, close the square, 3 IR 15. And what that basically means is if you want to define a case that was delivered in 2017, so it was delivered in 2017, there are typically 4 volumes of reports in the Irish Times. So the next number is the volume. So you could have 1, 2, 3 or 4. So this particular case would be volume 3 in the Irish reports and at page 15. So I will put up recommended reading at the end of this lecture. There will be an introduction to law handbook which covers some of these areas in more depth, and also in the recommended reading. So if you're interested in citation and how to find a report, you can also of course refer to those different resources. The second set of reports that are available in Ireland if you want to find a case is the Irish Law Reports monthly. The Irish Law Reports monthly are provided on a commercial basis by Roundtall, and you can find them in westlaw.ie. So the next source of law within the Irish legal system is legislation. So as I referred to, legislation, it's created by the Oireachtas, which has been given sole and exclusive power to make law within the Irish legal system, and that power is given to the legislature, or what we refer to as the Oireachtas, by Article 15 of the Constitution, which clearly says that the sole and exclusive lawmaking power within Ireland is conferred on the Oireachtas. Okay, so acts of the Oireachtas, legislation is often referred to as statute law, or an act basically, and so it can be divided into the primary act, a statute, and also then we have secondary or delegated legislation. So acts of the Oireachtas are a primary piece of law, will be created by the Oireachtas. The Oireachtas is made up of Dáil Éireann, Seanad Éireann and the President, and they all have a function within the legislature in creating law. Secondary legislation can often be referred to as statutory instrument, are usually pieces of delegated legislation where within your primary source, within your act, there will usually be a provision in there which delegates power to a minister to create statutory instruments, which are secondary or delegated legislation. So again, if you want to find a piece of legislation, the best place to find legislation is on the Irish Statute Book, so you can just stick that into Google, the Irish Statute Book, and you will pull up the web page, which I have a picture of the web page here. Basically, then you can search the database either chronologically or by year, or by the name of a particular statute. So then just a little bit about the legislative process. So we know that legislation is a source of law. We know legislation is made by the legislature, or the Oireachtas creates it, and it goes through typically a 5-stage process within the Oireachtas. I'm just going to briefly go through the 5 stages. You'll have the first stage, which is generally where permission is sought by a minister to introduce a bill. If permission is received, it will be the bill will be introduced and read, and then it will go generally for a second reading. It'll go into the second stage. The second stage is an important stage. It's a debate stage, basically. It's where the minister who is responsible for the bill, so the minister perhaps who's putting the bill forward, will debate the merits and the advantages and the need for either the amendment or the current bill, this new piece of law. At that point, you can have opposition, so members from the opposition parties who will get involved in the debate and possibly set out maybe the disadvantages, the errors or the omissions from a particular bill. So it's an opportunity for debate within the House. And then it moves on to the third stage. And the third stage, or also referred to as the committee stage, is an important stage. Is this point where amendments can be made to the original bill. So between the second and third stage is always a good opportunity if you want to, as a key stakeholder, somebody with an interest in a piece of legislation that's going through the legislative process, if you have an interest in its outcome or how it regulates a particular area, you could maybe have an influence by getting involved with a key spokesperson in relation to the development of the bill through the houses of the Oireachtas. So after the third stage, where amendments might be tabled and made, the fourth stage then will review any amendments that have been made in the third stage and send it forward for the final stage. So the bill again will be considered at this fifth and final stage. It will be considered, all of the amendments will be considered, and if it's agreed, that means it has been passed by both Dáil Éireann and the Seanad Éireann. Then it will be sent forward for signature by the President, and once the bill is signed by the President, it is enacted and then generally becomes law either on its day of operation, or you'll often find a provision within the legislation that will say, this act will pass on a commencement date that will be issued by the relevant minister. So you can look out for commencement provisions and also commencement orders, which you will also find on the irishstatutebook.ie. So those are the 3 main sources of law within the Irish legal system. However, since we became a member state of the European Union, the European Union possesses its own body of law, which have also both primary and secondary, and I'll refer to them in a second. But Ireland, because we amended our constitution to allow supremacy of EU law over Irish law in certain areas, means that we also have to consider EU law as a primary source of law within the Irish legal system. So primary sources and secondary sources of EU law. So the difference is the application or binding force in relation to these primary or secondary sources. So primary sources of EU law, an example, are the treaties, such as the Treaty of Lisbon. The treaties take precedence over domestic law and they have automatic application. The secondary sources are a little different, and secondary sources refer to if you see regulations or directives or recommendations from the EU. So regulations have immediate effect or immediate application. So they apply without any other need in Ireland to change or amend our legislation, in comparison to directives, where directives have binding force like recommendations, but generally this will involve the Irish legislature amending legislation to provide for the implementation of the directive. And you generally find these in European Community statutory instrument, which are increasing over the years. So recommendation then within EU law is of persuasive authority only, so it's not binding like the directives and like the regulations, for example. So those are primary sources of law within the Irish legal system. I'm going to talk now about secondary sources, and if you remember I said earlier the secondary sources of law are more of a persuasive value or persuasive influence. So there are a number of secondary sources, and I'm going to talk about customary law, international law, canon law, and also commentaries and scholarly writing as being influential and persuasive secondary sources of law. So if we look at customary law, and if we go back a little bit to the history of law within Ireland and the Brehon law, which is law that applied in Ireland before the common law was introduced by England. Brehon law was based on customary laws. So basically it's an example of a system based on custom, and the custom was administered then by justices that travelled around, justices known as Brehons. So important elements in relation to customary law is generally it's based on habitual practice that is continuous within a particular locality or community, and acquiescence to it, and it's continuous over a period of time, means that it has binding force in law. So there are two conditions that generally apply before it does enjoy the force of law, and that is that it is certain, reasonable and continuous, and the other is that it's customary, so it applies to a particular custom in a particular locality, community or area. So another source of law is international law, and international law governs states in their relationship with one another. So while international law at a general level applies between the relationships between one state with another, so for example Ireland with England, with the United Kingdom, or with France and Germany, for example. Whereas national law is the relationship between the state and individuals within the state, and between individuals and individuals. And I'll talk a little bit more about the divisions or classifications in public and private law in a few minutes. So in relation to Irish law, one of the principles in this area is that Ireland is referred to, or concept is Ireland is referred to as a dual estate. And what that means is that international law does not have direct application within Irish law unless we amend or incorporate it into our domestic legal system. We can incorporate it through either amending our constitution or incorporate it through acts of the legislature or acts of the Oireachtas. This is typically the way that we do. So generally an international law does not have binding force in Ireland unless it has been incorporated into our domestic law. So first of all, in order for Ireland to sign up to a piece of international law, we would generally sign and ratify a treaty. And just to give an example, the European Convention on Human Rights is an example of an international convention that Ireland has signed up to and ratified. But the European Convention on Human Rights is a convention that has been created and belongs to the Council of Europe. And the Council of Europe is different, just to highlight, from EU law that we spoke about earlier. EU law being a primary source of national law having supremacy over Irish law. The European Convention on Human Rights is it's a convention set up under the Council of Europe. So it's an international convention in the area of human rights. And in order for this convention to have application or effect in Irish law, as I said, being a dual estate, it must be incorporated into a piece of legislation. And this is an example. The European Convention on Human Rights was incorporated into Irish law in the European Convention on Human Rights Act of 2003. And what that means is that the European Convention now has application within Irish law through the provisions of the European Convention on Human Rights Act. And typically that means, in the context of judges administering justice within a court, if there's an issue in relation to a human right, is that the Irish judiciary must take notice, judicial notice of the decisions of the European Court of Human Rights, which is the court structure that deals with any breaches or violations of the rights in the European Convention on Human Rights. So another source of secondary law is canon law, and canon law comes from the Christian Church and the rules of the Church, and it doesn't hold any binding force in Ireland, but it has had a very persuasive or influential dimension in relation to the development of the law of marriage. So if you look at our family law system and the formalities around marriage, you can see the influence of canon law in relation to the development of our marriage law. And finally, a secondary and persuasive source of law that is commentaries and scholarly writing. So if there is no law on a particular issue, maybe no provision or statutory provision or constitutional provision, the courts will often look to scholarly writing to develop their arguments in relation to a particular area or a particular principle. So examples I have here is Blackstone and Hale, which have been highly influential scholars in previous centuries. There was a rule that only scholars who had passed away would be cited in judicial decision making, but that doesn't apply anymore, and you will see influential authors in modern textbooks being cited in judicial decisions or judicial arguments, such as Byrne and McCutcheon in relation to the Irish legal system, or Wiley, Kelly in relation to the Constitution. So up until now, we've looked at primary sources and secondary sources of law within the legal system. But sources of law are also divided up and categorized into different classifications or different divisions. So you might see terms such as substantive law, procedural law, and public law, private law, civil law, and criminal law. So sources of law are divided into substantive and procedural law. Substantive law is further divided then into public law and private law, and I'm going to look at each. And then you have procedural law, which is generally civil and criminal procedure in the courts, and the rules of evidence would fall within procedural law. So substantive law really refers to the rights and obligations that are conferred on individuals within statute or the Constitution, for example, but within the various different legal subjects such as contract law or tort law. So it's a substantive component of a legal rule, such as a right or an obligation that's been conferred by statute or the Constitution. And procedural law then is basically a body of rules that implements substantive law within the court system. So you'll have civil rules of procedure and criminal rules of procedure. And I'll talk a little bit about them later, looking at the divisions of civil and criminal law. So within substantive law, you have this public-private law divide. It's not always a clear-cut division, but we can look at some overall or general legal subjects that fall within the public law realm and the private law realm too. Generally in public law, we're talking about the state and its agencies, or it's generally concerned with the public interest, or with state agencies and the interest of individuals. So examples of that will be, one of the main examples would be constitutional law, administrative law, and also criminal law. So constitutional law then really deals with, and I talked about this a little earlier when I said the source, constitutional law, it confers it puts the different organs of state and gives them their functions and their roles, separation of powers. So it's concerned with the powers and functions of state and also the rights of the individual. So it has, as I said, the fundamental rights of each citizen are held within the Constitution. So it deals with public matters of public interest or public concern. And then you have administrative law, and administrative law basically is a body of law covering the administration of the state, the operation of public authorities such as local authorities. And then you have criminal law. So criminal law is basically the investigation and prosecution of offences. It's a public matter. It's undertaken by public agencies such as the Gardaí and the Director of Public Prosecutions. So those are examples of public law. And then when we're looking at private law, one way to differentiate between public law and private law is the different relationships. So in private law, generally you'll find that the relationship is between an individual and another individual, or maybe a dispute that has arisen between one individual and another. For example, within contract law, a dispute between a particular agreement or contract, or tort law, such as a dispute because of a civil wrong, because of some injury or harm. Family law and commercial law are also other examples of in the private law area. So if we look then at the divisions between civil law and criminal law, and I've referred to these earlier, but some of the main points here to allow you to differentiate between civil law and criminal law is the aim, the actors within each, and the remedies or redress that will be given by the court in these different areas of law. So you have in criminal law, the aim in criminal law is punishment, rehabilitation or deterrence from criminal behaviour and criminal conduct. So it's generally punishment which would lead to the remedies, which would generally be a fine or imprisonment. And then civil law is generally concerned with the issue of compensation, and placing a person that has been wronged in a place through compensation or through damages. So the remedies in that context will often be damages, injunctions, declarations, and specific performance are remedies that are often given in civil law, such as in contract law. You might find a redress or a remedy of specific performance, but also damages being the main remedy in relation to civil law. And there's also a difference between the actors. So as I said earlier, in public law, you'll often have disputes that might be between the state and an individual. So you might have the state versus an individual, whereas within civil law, it's usually an individual and an individual. So you might have a case that is referred to as Maloney versus Murphy, for example. And then, as I mentioned earlier, there are differences. So you have your substantive law, your rights and obligations that are conferred on each person, and then you have procedure. So you have court procedures in relation to the civil and the criminal law system, and there are some differences in relation to procedure. One being the proof that has to be adduced in evidence before the court. In criminal law, the standard of proof is beyond a reasonable doubt, versus in civil law, the standard of proof will be the balance of probabilities. So in criminal law, It would have to be proved to the judge and to the jury that the defendant committed a crime beyond a reasonable doubt before they could convict, whereas the balance of probabilities is, in civil law, is that a situation is more likely than not to have occurred. And that is an introduction really to the Irish legal system, and it brings us to the end, to a summary. So what we have looked at is the Irish legal system, the concept of a legal system, what is a legal system, what are the main characteristics, and we looked at it being normative, institutionalised and coercive. We looked at the notion of limited power, which is fundamental to the rule of law within any legal system. We also looked at the various sources of law. We have primary and secondary sources of law, and then we looked at the divisions within each source of law, being substantive, procedural, down to private and public, and also the difference in the divisions between civil and criminal. So the aim was to give you an introductory into all of these different areas, concepts and classifications of the law. And if you are interested and want to go more in depth in relation to this topic, I have listed a number of recommended reading, and you can refer to the recommended reading for further study in this area.